Representative Gilchrist, are you all set?
Yes, I'm all set. Thank you.
Okay, great. Okay, so, and Sam, are we all set to get the meeting started?
Yes, we are live, Senator.
We are live. Okay, great. Thank you very much. Good morning, everyone. We're going to convene this first meeting of the data privacy working group. Today's meeting is going to be focused on healthcare adjacent data. With that, I would like to introduce Representative Gilchrist, who is going to be the co-host and co-chair of the committee. So Representative Gilchrist.
Great. Thank you so much, Senator Maroney, and welcome to everyone. I'm really looking forward to learning with you all and just feel grateful to be in this position. Thank you.
Thank you very much. So with that, we'll go on. We're going to start by just introducing the members of the committee. So I'll just call your name and then ask you just to briefly introduce yourself. Then I'll go through the basic, the scope of the task force, and then at approximately 11:30, the hope is to our time, which is 8:30, I guess, Oregon time. We'll have the Oregon's Attorney General present. So with that, Representative Gilchrist already presented. Nancy Lieben.
Yes, hi, thank you. Nice to see you. Nancy Lieben, I chair the privacy practice at Davis Wright Tremaine in Washington, D.C. And a lot of my practice focuses on policy development, legislative issues, and so forth, as well as compliance issues.
Great. Thank you, Nancy. Caleb Williamson.
Good morning, everyone. My name is Caleb Williamson with ACT, the App Association, a technology trade association based in Washington, D.C. The portfolio covers a wide array of issue areas, including data privacy, competition and platforms, workforce development, anything that you can really touch on with tech and innovation, we engage in. So very grateful to be here.
Great. Thank you, Caleb. Dina Castricone.
Good morning, Dina Castricone. I am the managing member at DMC Law. I'm a privacy and healthcare lawyer, and I focus on health privacy issues as well as helping small and medium-sized businesses with privacy compliance and responding to data breaches. Thanks for having me.
Great. Thank you, Dina. Michelle Lucan, and do you want to just introduce yourself and then I guess the whole team from the Attorney General's Data Privacy Unit?
Yes, of course. Thank you very much, Senator Maroney. I'm Michelle Lucan. I head up our privacy section at the Attorney General's office, and we have pretty much our whole team on. So I'm joined by Assistant Attorneys General Anya DeMeo, John Newman, Michael Martone, and then also our paralegal Casey Ryback. It's nice to see many of you again. I know we've had a little bit of a break, but nice to see you all.
Great. Thank you very much. Bob Ridgway.
Morning, Senator. I'm Bob Ridgway. I work with AHIP, and AHIP is the national trade organization representing most, not quite all, most of the health plans across the country, including most of the Blue Cross plans. And like Michelle, it's kind of good to see some of these familiar faces again when we worked on the legislation itself. And now I gather we're going to learn a little more. I certainly learned a lot the first time around. Thank you.
Thank you, Bob. Jay Somerson.
Thanks, Senator. Jay Somerson. I'm on the Microsoft State Government Affairs team and work primarily on policy issues in a region that extends from Rhode Island over to Indiana down to Virginia.
Thanks, Jay. And Andy Kingman.
Yeah, hi, good morning, everybody. Andy Kingman here, president of Mariner Strategies. I represent the State Privacy and Security Coalition. Great to see and hear so many of you all again. And, for better or worse, this is what we live, eat, sleep, and breathe in all 50 states. So look forward to working with you all.
Thanks, Andy. Marion Breeze.
Good morning, everybody. My name is Marion Breeze. I work with Archive 360. It's a company that works with state and local governments as well as federal agencies and heavily regulated organizations, both in the healthcare and FSI space, on data security, data privacy, and managing data in the cloud. A pleasure to be here today. Thank you.
Thank you very much. Paul Martino. Let's see. Okay. David Stout.
Everybody, nice to see. I'd like to echo Michelle's comments. Nice to see everybody again. Familiar faces here. It feels like Groundhog Day all over again. But Dave Stous, I'm in Denver, Colorado, a partner at Hush Blackwell, and do data privacy, as you might suspect, given the nature of what we're doing here. So.
Great. Thank you, Dave. Eric George.
Morning. Thanks, Senator Maroney. My name is Eric George. I'm the president of the Insurance Association of Connecticut, and we represent the property and casualty and the life insurance industries in Connecticut. Thanks for having me.
Thanks, Eric. David McGuire.
Good morning, Senator Maroney. David McGuire, Executive Director of the ACLU of Connecticut, and we do a lot of work on privacy as it relates to civil rights and civil liberties. Happy to be here.
Great. Thank you. Professor Sudhir.
Hi, happy to be here. Thanks, Senator Maroney. I'm a professor at the Yale School of Management in the marketing group. I've been working on research relating to privacy, algorithmic bias, etc., from the perspective of both consumers, firms, and overall social welfare. So this is great to see here and hear from multiple perspectives on this here. Thank you.
Great, thank you. Alex Lipton.
Hi, good morning, everyone. My name is Alex Lipton. I'm Deputy General Counsel at Unite Us, a company that helps connect health and social care providers to coordinate social care. It's great to be here. Thank you.
Thank you. John Grant.
Good morning, everyone. My name is John Grant. I am Director of Government Relations at Find Help. We are a B Corp that connects people to social services. Looking forward to talking to you more later.
Great. Thanks, John. Antoinette Webster.
Good morning. My name is Antoinette Webster. I'm from the Department of Administrative Services, the Procurement Unit, and we handle statewide contracting. Looking forward to the discussions coming up on this board.
Great. Thank you very much. Evie? I think she may have been getting on the.
Hopefully it's coming through.
Okay, yep, there you go.
Hi, Senator Maroney. Thank you
Hi.
so much. Calling in from Palo Alto today. So my colleague Eric is also joining for today's meeting. I'm Global Policy Director at Credo AI, and we are focused on developing responsible AI systems and addressing and identifying AI risk management. Thanks.
Thank you. Kier Lamont, actually, he may be on a flight, I believe.
Hello, Senator. I am taking Kira's place. I am Jordan Wrigley with the Future of Privacy Forum. I am the health researcher and lead for our health portfolio. So it's great to be joining you, and we'll miss Kira, of course, but I look forward to having him next time.
Thank you, Jordan. And you'll be presenting later, correct? So great. And Kyle Farth.
Kyle's on a flight as well. And now
Kyle is on it, yeah.
So
Kate Goodlow.
Good morning and thank you. I'm Kate Goodlow. I'm a Senior Director of Policy at BSA, the Software Alliance. We are a trade association of enterprise software companies, so think of us as the B2B slice of the technology industry. We're a global organization, and I lead our policy team's efforts on privacy and AI at the international level, the federal level, and in the states too. So very much appreciate the opportunity to be here.
Great, thank you. Melissa Riley.
Good morning. Good morning, Senator Maroney and Representative Gilchrist. I am Melissa Riley, the Director of Government Affairs for Hartford Healthcare here in the state of Connecticut. Thank you so much for including me.
Thank you. Joseph DeMarco.
Good morning. My name is Joseph DeMarco. I'm from Greenwich, Connecticut. I have my own boutique law firm, the full-time focus of which is the law of data privacy and security and cybercrime prevention and response. I regularly represent individuals and businesses here in Fairfield County, also throughout the state, on complex issues of data privacy and security, and I'm honored to be here today. Thank you very much.
Thank you. Scott Copperthwaite.
Nicely done, Senator. All right. Good morning, everyone. This is Scott Cowperthwaite. I'm the lead privacy and cybersecurity counsel at Charter Communications, which is headquartered in Stamford, and we are a connectivity company that offers telecommunication and broadband internet services across the country. So thank you for having me.
Thank you. And Karen Buckley.
Hi, good morning. I'm Karen Buckley. I'm the Vice President of Advocacy for the Connecticut Hospital Association. And I'm here today. Thanks for welcoming us to the committee. And I did bring with me Jen Cox, who is our outside legal counsel, who was part of the conversations last year. So she's also, she's with Cox and Swicky, and she's also on the line today.
Okay, great. Thank you very much, Karen. And so with that, we'll just go through, the way we're going to work the group. One, I think just to echo the sentiments that it is great to see everyone again, and to really just thank you for all of the work that went into getting the legislation passed. A belated thanks, and remiss without really expressing how much appreciation I have for all of the work that went into it and all the work and time that so many of the people on this call gave to trying to make that make our legislation the best that it could be. Special thanks to the Attorney General's Data Privacy Unit, Michelle, Luke, and Anya, John, Michael. We definitely spent a lot of time together working on that legislation. So if I haven't expressed, I don't think I can possibly express how much appreciation I have for all of the time and effort that went into that. So with that, the way we're going to run the working group will be similar to how we did it in the past, that the people, we welcome people to sit in, and this one is being broadcast, I believe, on CTN. And I think we are going to broadcast these meetings this time on CTN, and they are being recorded, just so everyone is aware that they are being recorded and broadcast. We will open the questions to the members of the working group. So we do, welcome other people to sit in and listen, but as far as the discussion, that will be limited to the people who are within the working group or the invited guests who are speaking during the meeting. The meetings we have set up, so today is on the healthcare related data. November 2nd, we are going to be holding a meeting on AI and algorithmic decision making. November 30th, we will be looking at the children's privacy protections. December 14th, we are looking at the data co-location, and then also part of the charge of the working group was whether we needed to expand the rights to any other groups. So, and then January 3rd will be a final meeting to kind of go over recommendations from the committee. So we will hope to, unlike last year where we started with language and we kind of worked on that, this year we're actually looking at if we need to create any additional language. So as of now, there's no language to look at, but I expect in the December timeframe, So between the December and the January meetings, we'll have language to look at and go back and forth on. So we do will appreciate that input. If we do think so for the AI, just to give you what the plan is, we would like to have someone present on European Union, someone to present on the American Data ADPPA provisions related to the AI and the algorithmic decision making. And we have also reached out to Washington, D.C. to get someone to present from D.C. on their bill regarding the AI and the algorithmic decision making. If you would like to present, or please reach out to me on that, and we'll see if we can fit that in. We are going to try to keep these meetings to between 90 minutes and 2 hours. So planning on 90 minutes with the hope the discussion won't bring it above 2 hours. The children's privacy protections, we're going to look at getting someone to present on the California Age Appropriate Design Code, the UK Age Appropriate Design Code, and then also some of the other provisions from, I believe, the ADPPA and some other, if there are other state laws we need to look at that time. And then the data co-location. So Karen, I think we're going to have you guys present on your issues with that. And then we're also looking to reach out to Senator Rodriguez to present because Colorado did not exempt nonprofits in their bill. So I just wanted to understand why that was done and look if that's something we needed to change or narrow down the codes, within there. But not saying we're going to change anything, but I just wanted to look at what was done in the other areas. And then January 3rd again would be the recommendation. So with that, so the agenda for today, we have Kimberly McCullough. Kimberly, are you on? Now Sam is, let me look. Not yet. Okay. So I think we may change the order then, and we'll have her come on later on. So we may change up. The next was going to be presentations on the social care data by Find Help and Unite Us. And then Jordan, we were going to have you present after that on just healthcare adjacent data. And again, some of this, given the Dobbs decision, I think there is even more interest in how we're going to protect this healthcare related data. So with that, why don't we go to see if John, if you would present. I'm just looking on my screen. I see John, Nancy, and Alex. So I'll have John present. And then if Kimberly gets on, if it's okay, Alex will have her present before you do. I think she had a limited time frame. So
that works.
Okay.
Fantastic. First of all, can everyone hear me? I see a one thumbs up. That's good.
Yes.
And everyone is seeing this presentation. A miracle has occurred. Thanks, everyone. I really appreciate it. My name is John Grant. I want to start this off by saying thank you to Senator Maroney and Representative Gilchrist in particular for making the time here today. We know this is a really busy time of year, and appreciate the attention to detail to some of these other pieces. I know that you passed this last year, and I'm sure you thought you were never going to think about this again, and here we are. So again, thank you for taking the time here. I work for a company called Find Help. We are a B Corp. That means that we are a company that has a social mission at our core. Our mission is to connect people seeking care with the programs that serve them with dignity and ease. That means that we've made a large index of social care providers. As a B Corp, anyone can go onto findhelp.org and search from by zip code to find if any kind of services that might be available, free and reduced cost services that might be available in your zip code, whether that's food pantry or getting dental care or et cetera, et cetera. And again, that's something that we provide free of cost as part of our charter as a B Corp. And we're here today to talk about social care data privacy. We exist as a company because our founder, our CEO, Aaron Gray, was getting ready to leave to go to college. And his mom, who was a janitor at a local community college, suddenly contracted rare brain disease. She was rendered permanently disabled. And as a teenager, Aaron was trying to navigate how to get from here to social services that were over here, and found that, unfortunately for him, that meant a lot of zigging and zagging and a lot of closed doors and going down a different route to get there from here. Ultimately, he realized that there was had to be a way to do this that would provide people to search for care with dignity and with ease. And thus, as a company, we were born about 11 years ago to try to help even that line out, to make it a little easier for people to access social services. So we're here today, though, to talk about social care data privacy. So I think it's really important that we start this conversation off by saying, by trying to figure out how is social care data sharing regulated today? What you'll see here, this slide, you might look at it and say, oh my goodness. The reality is that in today, HIPAA, which I think everyone knows is the federal policy framework that governs healthcare data, protects social care information in certain settings, and that there are gaps in that policy. Social care data includes data generated through screening and assessments, referral data, outcomes data like services received or not received. These data can originate through self-navigation from a community-based organization that identifies a need for services that they can't fulfill, or from professional navigators like care managers or social workers who may be employees in a healthcare setting, a government agency, or another kind of setting. Depending on where the data originates and the type of organization that receives a referral, the data may or may not be PHI covered by HIPAA, that means personal health information. If the data originates in or is received by a HIPAA covered entity, it is PHI. This diagram, though, I think demonstrates the diversity of the pathways for social care referrals. Yellow lines represent PHI, brown dotted lines represent data that is generally considered not PHI. The point here is that social care data can originate from many industry users. That means that this data is not treated the same at the outset. For example, a food bank referral that originated from a hospital discharge planner is considered protected health information. It is protected by HIPAA, and the patient has a consumer right under the Cures Act to access that data. However, if a consumer originated that same food bank referral on a kiosk on their own accord, that data is not personal health information, and it would only be bound by the terms of use and privacy policy of the technology company that provided the digital tools to enable that referral. This is really the policy problem, and this is what policymakers around the country are beginning to examine and address. So how is social care data protected? This is kind of more of an individual example. And I think this just really illustrates that previous slide a little more directly. If a seeker, in this case, goes to a community center and they want to find two different kinds of social care referrals, one is to a food pantry, you'll see that is not protected. But if they get a referral to a health clinic, that is protected. And that those practices would remain unaffected. So we think that it's important as a company, we always center the people seeking care at the core of all of our decision making. And that's why we think that as states and even the federal government are considering privacy in this sector, that the seeker gets centered in those decisions. I think as demonstrated by both the composition of this group and the previous graphic, there's a wide range of participating industries and social care networks. And it reinforces that social care referral data are different than healthcare data. So what does it all mean? In a healthcare context, most of us are comfortable sharing our health information with a network of healthcare providers because it could save your life. It improves care coordination and is strictly governed with robust protections under HIPAA. What's happening in this space is that some vendors or government agencies and social care networks extend that HIPAA consent model to a broad network of social care providers, including self-referrals and referrals originating with CBOs. At Find Help, we implement and we are advocating for a seeker-first privacy model for social care. So what does that mean? Let me tell you. I'm going to violate the #1 rule of presenting and read a slide to you. When it comes to social care, we think that social care referrals originating outside of a HIPAA-covered entity, including self-referrals, should follow a consumer-directed privacy model. HIPAA-covered entities would continue following their existing pathways, but non-HIPAA-covered entities should instead use per-referral consent and permission-based access. Social needs data can be very sensitive, and networks with many diverse types of organizations, some of them are HIPAA covered and some are not. So we think that part of the per referral consent and permission-based access is really critical to protect the data from an individual's perspective. As a best practice, we think per referral consent, seekers have to consent before they have their information sent on each instance of referral, and that seekers have the right to revoke that consent at any point. As far as permission-based access, organizations should limit access to seeker information to only what's necessary for the provision of those services. And finally, the seeker access to services, regardless of consent, that organizations may not condition providing services on seekers' consent to additional data sharing. We're getting a little tight on time here, but I just want to demonstrate, this is kind of a broader view of what we're talking about and how things are visible inside a referral network when you're looking at both a permission-based access and per referral consent. You as the seeker have some control over who is seeing your information versus everyone seeing every referral in a network where those protections are not provided. And here's one last example that I think is important just to illustrate this one more time. This shows a referral from a social care organization to another. And I think you can see here that who is seeing this and who isn't, and why those protections may be considered very important for the end user, again, the seeker, that should be kept in mind throughout these conversations. I want to leave you with, first of all, here's my contact information. And I wanted to thank, again, Senator Maroney and Representative Gilchrist for starting this conversation. But I don't think it's a big secret that during the pandemic, there was at the height of the pandemic, when things kicked off in March of 2020, that there was a massive spike in the need for social services. It was unprecedented levels. So the world was totally disrupted. I live in a working class neighborhood, a lot of different kinds of people, a lot of different backgrounds, a lot of different kinds of jobs. Our next door neighbors are immigrants who were working 3 jobs, lost all 3 in the pandemic. They, at the bottom of our hill is a food pantry. I am willing to guess that many people in our neighborhood ended up having to go down the hill to get some food. At the core of what we're talking about is those folks who are at a challenging moment in their life should have some say over who's seeing that information and who is not. And we want to just make sure that those who are seeking that care are receiving that care with dignity and with ease. So with that, I will turn it back over. Thanks again for your time.
Great, thank you. Are there any questions? If you could use, again, so for the members of the committee, if you'd use the raise hand function, if you did have questions. I do appreciate some of those graphs. It made some of the things more clear for me in terms of what is protected and how it, it might not end up being protected data. Now, I believe you've already sent a copy of that, of your slides?
Yes, we did, Senator.
Okay, great. So then what we'll do is we'll make sure we distribute those to all of the members of the group. And then if anyone else who's not unofficially would like them, we can send them to you as well. So just send us an email after the meeting. Okay. I don't think I have questions right now. I think that I will have some later. Representative Gilchrist, do you have any questions? Oh, I do see one hand raised as well.
I think that might be me. Thanks, Senator Maroney.
Okay.
Yeah, my question has to do, if you could just speak a little bit more about the permission-based access. What does that look like?
I'm going to kick it to my colleague Danielle, who's on the phone here. Danielle, would you do you want to answer that one?
Hi, yes, Danielle Nasser with Find Help. So basically, permission-based access is about making sure that only the people who need access to data in order to do their jobs and deliver the services to the seeker has access to that data. So it's about making sure that all of the CBOs and all of the organizations that are part of a social care network have policies and practices in place to ensure that not just anyone in the organization can do a name-based lookup to search for whoever is seeking services from any organization within that social care network, making sure that access to the data is restricted and also allowed, and ensuring that the people who need the access in order to deliver the services have that access in order to deliver them as seamlessly as possible.
Great, thank you.
So I may have I have a question, and I may have to follow up later just so I'm understanding. So it sounds like if a referral is initiated from within a healthcare setting, it is HIPAA protected. It becomes protected data. But if the referral, so if someone were referred to a domestic abuse shelter and that referral did not initiate from within a healthcare setting, that is not protected data. Am I understanding that correctly?
Yes. So currently the way that HIPAA, the privacy rule in HIPAA is written, anything originated or received by a healthcare entity is considered protected health information. But if it originates within a CBO, that's not considered a HIPAA covered entity and only is sent to other CBOs or other non-covered entities within the social care network. Those are not considered PHI, and there's currently no overarching privacy model or regulations that govern how that data can be shared.
Okay, great. Thank you very much. Are there any other?
I have a quick question.
Sure.
I was just wondering if you could comment on the current language of the data privacy law and whether it strikes the right balance. I know that the definition of sensitive information in the law includes a person's mental or physical health. And then I know it's also, it requires a review of the four corners of the law, and there's some exemptions and application thresholds that we'd all need to be mindful of, but was just wondering if you could speak on the current language and whether that language is sufficient.
Just to be super clear, you're talking about SB 6?
Correct.
Okay, great. I'll be honest, have to take a quick review of that, and we can get back to you by the next session, but it's a great question.
Okay, great. Michelle, thank you for the question. And so yeah, we'll look forward. If you could get back to us on that, that would be great. Okay. All right. So now we'll move on to Kimberly McCullough, who is on now, and we're very happy to have her here and honored that she's taking the time to speak to us. So she's a representative from the Oregon Attorney General's office, and I believe she's going to provide us with an update on how Oregon may address healthcare data in a post-Dobbs world. So, Kimberly?
Yeah, thank you. Thank you, James, and everyone else for having me here today. I have a few things that I'm going to go over with you. I will say we've been wrestling with these issues, as I'm sure you have been, and folks across the country. I wish I could say that I had more answers at this point than questions, but I do feel like we still are really working through a lot of questions. You know, I also would love to be able to share some materials with you today. I'm still in the process of kind of figuring out what I can and can't share. We had a task force that was formed in Oregon, and we came up with a whole bunch of recommendations, and then we're about to release our sort of report. And then there was some consideration of, wow, we're right before an election. Do we actually want to provide this much detail at this point? And so I am now kind of like in the process of figuring out, well, okay, what can I share with friendly folks? So to the degree that I can share things, I will definitely circle back.
That would be fantastic.
Thanks. Yeah. So I will say, you know, in the consumer privacy context, we actually are a little bit behind Connecticut. We are looking to pass our own statewide comprehensive privacy law this next session, and we are actually looking to Connecticut law as one of the 5 states, or I guess it's 6 now, that as examples. And I heard as I was joining this conversation about sensitive data, and we're basically including that same definition that you have in your Connecticut law. I will say we have as a task force looked at the federal My Body, My Data Act, and I don't know how much you all have discussed that, but there are a few things there that we certainly are interested in, but we haven't decided necessarily to move forward with. But I think that the main things that are different in that federal My Body, My Data Act that I think could be helpful as additional protections to the consumer privacy law is the minimization of employee access. We really felt like that is a place where it's really worth some conversation. Requiring a specific policy about reproductive health care data as opposed to just a privacy policy overall. Although in our conversations about that, our folks who are like HIPAA experts have basically said, privacy policies can be misleading. And so probably want to be a little bit careful there rather than, because some folks will just say we're HIPAA compliant, but they're not actually covered by HIPAA. And so if we were to do something related to a privacy policy, we might want to get more specific than that. And essentially like a clear yes or no statement of whether or not you are a HIPAA covered entity, and if you're not, then what exactly are you doing to protect the data? I can't remember. I don't know that any of the state level privacy bills have had a private right of action. I'm sure you all struggled with that as we have. It's really difficult to get something like that passed in Oregon. But that certainly would provide a little bit more protection. And then I think the biggest thing is just that it has narrower exemptions than our state bill, right? Like and in particular, as it relates to law enforcement access, although the response that we get back from industry is, well, we don't, are you going to stick us in a difficult position? California just recently passed legislation that sort of puts industry in the position of having to follow one state law versus another state law. And I don't know if we actually want to do that or not. It's like putting them in a rock and a hard place, right? And so I guess what I will say, these are all things we've discussed, but we haven't really landed on anything super specific. We also did look into just other information that might be shared in the context of civil and criminal actions. And I believe that Connecticut actually already has passed some legislation related to subpoenas and warrants. I don't remember what you all have passed compared to California, because California has done a lot more. And I think the thing that we're a little hesitant actually to pass something in this particular context because we haven't been able to figure out the logistics. And so we're talking to our judicial department, and we have sort of a team of judges that are looking at this. How do we tell the court, don't reissue subpoenas from other states when they relate specifically to abortion crime in another state or reproductive health care. We've also been looking at everything in the context of gender affirming care as well. And basically what we've gotten back is, how do we do this, right? How do we do this without a lot of research? I think that's the same thing that we've run into as far as like preventing, don't arrest someone on an abortion crime from an out of state arrest warrant. How does law enforcement actually know that if it shows up in the law enforcement system as a felony or an extraditable felony or even like manslaughter, it's not necessarily going to show up as as something obvious. And so we are working through that, but I don't know that we will pass something in that area. You're going to hear a theme here, which is a lot of questions. We also looked into geofencing warrants. That was something that was brought to us by some folks that had been working on legislation in New York. Interestingly, on the geofencing warrant, so just to make sure everybody, I don't know what all of your knowledge base is here, right? But geofencing warrant is basically like, we want to know everyone whose cell phone pinged a tower within this particular location, right? The concern there, the way it was brought to us was, well, we should not have geofencing warrants because of the fact that someone could seek a warrant for all the folks that went, for example, to a healthcare facility. But when we actually we're looking at this sort of cross-jurisdictionally, the request wouldn't be coming from someone inside Oregon because we don't have anti-abortion laws, right? It would be coming from someone in another state or law enforcement in another state. And at that point, our state level restriction isn't actually going to do anything, right? Like that's not actually going to stop them from jurisdictional issues will probably be what come into place there. And then the other piece of it is that if, for example, we're talking about Google and Google has, if they're able, or any other entity that has geolocation data, but if they're able to be served in another state, whatever we do at our state level isn't actually going to make a difference there, right? And so in that particular context, we also then started talking about, well, we're looking at passing a state level FACE Act, which I don't know if you all have. Washington has a really great comprehensive one, but that's basically to protect clinics from interference, and it has civil and criminal actions that can be taken to protect clinics from folks who are interfering with those clinics. And in that particular case, we may actually want to use a geofencing warrant in Oregon to be able to identify who actually caused harm to a clinic. And so we're like, wait a minute, this actually could do the opposite of what we would like it to do. And so we have moved away from the geofencing warrant area. So the couple of areas where we actually have decided that we are going to do something. One is we're setting up an address confidentiality program for providers and then individuals who are seeking care. We have an address confidentiality program, which you may have in your state for domestic violence victims. And there are a few other states that have expanded those programs specifically to healthcare providers, California, New Jersey, and New York. And so we're basically going to do the same thing here in Oregon, which is just open up access to that program. So basically you can get a PO box, you can get all of your government documents and your driver's license and all of that switched to a new address. So that will at least provide some privacy for providers who want to seek that out. In particular, Oregon does not have any restrictions on abortion. And so we do have some late-term abortions and late-term abortion providers, which I know that's a challenging issue for some folks, but when you actually hear the stories of the people who need those abortions, it's oftentimes incredibly tragic and really difficult situations. And so the providers that are providing that care in particular in Oregon have a lot of concerns. And then we also looked at ways that our public bodies are disclosing data. I don't know if you have an analogous law, but we have obligations for our medical board that licenses medical providers to provide notice to district attorneys when an investigation uncovers conduct where a person may be subject to criminal prosecution. And so they're then having to turn that information over. We're clarifying those laws to make it clear that they only have to notify when it's related to something that would be a crime in Oregon as opposed to another state. And similarly, we have requirements that our medical board disclose information to other licensing boards when there is just confidential information. And so we are limiting that, limiting those restrictions, or excuse me, those requirements for disclosure. So that is kind of the overview of what we've been looking at, and happy to answer any questions. I wish that I had more answers for you all, like I said, but we really are still sort of wrestling with things, and always interested to hear what you all figure out as well, so that we can cross-pollinate.
Thank you so much. And yeah, I think you're right. It is such a kind of a new frontier that there are a lot more questions than answers at this time. So let me open it up to questions to see if anyone else has a question. And let's see, I see a few hands raised. So I'll start with Representative Gilchrist.
Thank you, Senator. Thank you so much for being here and for the information you shared. Has your group had any conversations about crisis pregnancy centers or limited service pregnancy centers and the information that they obtain from women, and what might be done in your state to address that?
Oh, that's really interesting. I mean, we've had a lot of conversations about crisis pregnancy centers, but not about the information that they obtain from individuals. That actually is a really interesting angle, and one that now I'm feeling like we probably need to take a look at. You know, I mean, crisis pregnancy centers in general are really difficult, as I'm sure you all know, and that like trying to regulate them is really difficult under our current Supreme Court law. We are working on a public education campaign for folks, and we already have the ability under our state Unlawful Trade Practices Act to do enforcement actions against crisis pregnancy centers if they are engaging in any sort of deceptive activities. I know not all states have that under their well, we call it the UTPA. I think other people call it the UDAP. But so I know some states are looking to sort of expand their laws to make sure that because they don't charge, right? And some of the Unlawful Trade Practices Act laws like require that there be some sort of monetary exchange. Our law is broad enough, but they're real tricky, right? Like the information that they provide, they are very, very careful to try to provide that information in such a way that it makes it difficult to enforce against them. But as far as the information that they obtain from folks, we have not actually looked at that, and I think that would be really, really worthwhile.
Great. Well, as we might do something too, I'll be sure to loop back.
Thank you.
David Stout.
Thanks, Senator. Hi, Kim. Well, first, thank you for joining us today. We really appreciate it. I know it's early out in Pacific time for you. I was hoping you might be able to provide, within the bounds of what you're able to say, some more around the timing for what you guys think you may release some stuff. Not looking for you to spill the beans on stuff you can't say. But just in the context, the work group here is looking, I think Senator Maroney said we're going to look at publishing something in early January that would be sort of like the work group findings, and kind of interested in knowing whether we'll be able to see what you guys have done first.
Yeah, so the Speaker's office is they're sort of the holders of the report, and what I have heard from them is that they will be releasing our sort of an executive summary, which is going to be reasonably short and maybe not that informative, sometime in the next couple of weeks, and that then shortly after the election we'll be actually releasing the full report, and it is very extensive and includes information not just in the privacy realm, but we're doing a whole variety of things to increase access and build up our infrastructure, prevent in-state prosecution doesn't really happen in Oregon, but we're kind of trying to make our state like a model as far as like the laws that we have. So there's sort of a variety of different things that we're going to be doing. We're going to be expanding our codification of the right to abortion. We have a right to abortion, but we're going to expand that to reproductive health care and gender affirming care broadly, possibly gender affirming care broadly, depending on where the advocates want to go. But yeah, so sometime after the election, that should happen. And then our legislative session starts in the beginning of February. And we have I don't know how you guys do it there. We have a long session every other year. So it's February to July. So that's when the legislation will be considered.
Thank you.
Thank you. And we are similar in that we do have a long session, although we're just a 1 month shifted. We're January through June next year. So I have a question, and I'm not sure. Well, let me just ask the question. I'm not sure if you're the right person to answer it, or if you can answer this, but when you were speaking about the geofencing warrants, it did bring up an issue to me, right? We define location data as sensitive information, right? In our bill, I think it's believed within 1,750 feet, but I don't know if there's a further way to protect someone's location data if they're going to healthcare facilities, right? And so if you can purchase location data, right, of people who've gone to certain clinics, how do we make sure that information is more protected, or is it already under the HIPAA?
So, so under your Connecticut state law, that sensitive information, yeah, you're saying it has additional restrictions for geolocation information, but there are so many exceptions, and then also it's a consent model, right? And so, I mean, I think, not to be patronizing, but to the general public, but I think consent models have problems, right? Like, even if you have to opt in, people want to opt in order to get something or to get a service, and so it does seem like there potentially could be some ways to tighten that up, or to limit the exceptions there. But I don't know that we haven't figured out something specific as far as like what the right model is. I think we're trying to get up to speed to where Connecticut is on that, and then see where we can go from there.
Okay.
Yeah.
And so that, I guess, question I would put to our to Michelle, to our Attorney General's office, is something that I would like to look on, because I do agree. Like, I know, like, my son and my in-laws use an app, right, so that they can track each other, but I don't think they read the privacy policies and understand that location data can now, because they opted in, can now be sold, right? And so are there certain locations that we should just prevent from that data from being sold, whether or not someone has opted in to allow that? So that's something I would like to look at going forward. So I apologize for talking too much. Are there any other questions for the actual real expert here for Kimberly, other than hearing me opine? Okay, if not, thank you so much. And I would appreciate, when you do have information that you can share, if you could share that with us, and if there's anything that we can share with you or be helpful to you, please let us know.
Yeah, please do. I would love to see what you all are developing. And like I said, I think we all just need to cross-pollinate as much as we can, since we're all sort of trying to figure out the same thing. So really appreciate your time and having me here. Thank you.
Great. Thank you again.
Thank you. Bye-bye.
Okay, with that, I think Alex, are you ready? Alex Lipton?
Yes, thank you, Senator. And
yeah,
that was great. I'm really happy that we were able to have Kimberly on. Thanks for that opportunity. And thanks everyone for joining today. Again, my name is Alex Lipton. I'm Deputy General Counsel at a company called Unite Us. We connect health and social care providers to help coordinate care across the country. I'm going to just pull up my presentation, just one moment. And while I'm doing that, thank you again to Senators to Senator Maroney and Representative Gilchrist for this opportunity. We strongly supported SB 6 to answer the AG office's question earlier. We strongly supported that bill. We think that it does a fantastic job. It's rare. States have had a lot of trouble passing comprehensive privacy legislation that's protecting consumers while also recognizing some of the work that's happening at the federal level with covered entities and others. And so thought that the bill did a fantastic job striking the balance for those folks seeking both health and social care services. So just very quickly, I want to be sensitive to folks' time. Again, we provide social care infrastructure to enhance care coordination across the United States. We were founded by 2 veterans in 2013 who, when they returned from service, tried to themselves seek care and then also help other veterans seek care, and found that it was incredibly difficult to do so. They set up a system to help veterans more easily connect to social services, and in almost no time realized that that system was not just something that veterans needed, it was something that folks across the country needed. So we founded in 2013. We've since grown to be in 44 plus states. We're in 20 states with what we call statewide networks, which means that there's active and accountable community-based organizations providing services in every county in the state. We have more than 850 folks working directly in these 49 states, including what we call community engagement managers, who are working on the ground with community-based organizations to make sure that this technology is aiding their workflows, not creating additional work and additional burden for community-based organizations, which we know is a huge focus, especially coming out of the pandemic, because these organizations are very resource constrained. And so we've been working very closely with these organizations to make sure that the technology is seamless for them and reducing their work hours. We have more than 720,000 services available across our networks. Importantly, we focus on not just what resources are available in the community, but also on outcomes. And so on average, the average time to referral acceptance is less than 2 days, which means folks are actually getting connected to services. 71+% of requested needs are met. That means when someone's sending a request, we know that sometimes, they're not eligible for services from an organization, or the organization simply does not have the capacity to meet the need. But we are meeting the need of the vast majority of requests that are being sent through our platform. And as a result, we've had 10.4 million connections to care. We're trusted across public, private, and nonprofit sectors. We serve as the statewide infrastructure in North Carolina and Rhode Island and Virginia to coordinate care across health systems, MCOs, care providers, and agencies. We also work closely with health plans, across the country and major health systems, including Kaiser, Cleveland Clinic, and others. And then we also work very, very closely with our community-based partners, such as Goodwill. We also, in Connecticut, work with CT211, who supports our work. So what do? We have a tech-enabled platform, a software as a service platform that enables organizations to screen and assess needs, to coordinate care together in a secure manner. And we also feature interoperability, which is a huge focus and one of the things that I want to raise today, not just what's happening at the state level, but also what are we seeing at the federal level when it comes to health and social care data, and what efforts are the major agencies that are working with health and social care providers working through to try and actually support deeper care coordination. Like I said at the top of the call, we're community focused. So we focus on an on-the-ground team. We found over and over again that placing technology in the hands of folks without really helping them work through what they need and what their best workflows would be, what their sensitivities are, how they want their org to be configured, what user level permissions they want, what organization level permissions they want, that doesn't work. And so we work directly with organizations to make sure that the right smart permissions are configured for each organization. We also have our own care coordinators. So we found that the resource burden placed on organizations right now is very, very high, and we can actually help coordinate care directly. So referrals can be sent directly to our care coordination team to help make referrals to the direct service providers as well. And then finally, as I mentioned earlier, we're really outcomes driven. So it is not helpful to have, what I would call maybe like a phone book style model where referrals are being sent, but you don't know whether the referral resulted in an outcome. You don't know whether someone actually got the service that they needed. So we provide structured outcomes for all of our referrals, real-time data. We have aggregate data visualization so that I know this is a focus in Connecticut, for example. You can see what are the health equity impacts of this work in this region? Like, on average, are BIPOC individuals being served as effectively, as quickly as, their white counterparts, as one example. We also provide analytics for community organizations. So they can actually, and this is a big focus we've seen, is these organizations are doing this great work. They want to use this technology, but they also want to be able to document the great work that they've done so they can build capacity themselves. They can go and get the grant or go prove to the state all the great work they've done. At no cost, we provide those community organizations dashboards to help them prove their impact to the state and to others. So the very simple workflow that takes place through Unite Us is Tom, as an example. These are fictitious people, obviously. Tom shows up at Mary's organization. Mary screens Tom, sees that he has any number of needs. Mary can use our platform to document Tom's consent and then electronically refer Tom to multiple community partners. She can seamlessly communicate with those providers in real time and securely share Tom's information with those providers. And then importantly, once Tom has actually had a documented, has received care, Mary can see that that case has been resolved. And so we can receive real-time updates to support Tom's total health journey. On the privacy side, which I think is the focus of today's call, what does that look like and what do we focus on at our organization? So importantly, we don't just do this CBO to CBO. I know that was mentioned earlier on the call. Any organization that's sending a referral, consent is required and documented for every referral. So if you're at a health system, you have to complete the consent. It's required and documented for every referral. The providers that are serving individuals can see the documented consent. So from a technical perspective on our platform, if consent does not exist, or if someone has revoked their consent, it is technically impossible to send a referral. You cannot do it. We developed our consent to prioritize client privacy, health equity, and accessibility. What do I mean by that? It's translated in 30+ languages. It's available in 6 formats. We found that, especially in rural areas or for folks that are, having to move quickly, sometimes they might not be able to, work in person with someone. Maybe they're, working telephonically. They want to be able to send the consent, have that person have the time, or maybe they're in the office and the person's busy. They say, hey, I can't read this right now, but can I look at it later? Of course, we can securely send a text message or an email with the consent. And again, no referral can be shared unless that consent is completed. Now, let's say the individual does not want to consent. It's still the case that individuals can access services regardless of consent. So the individual can be shared resources or can be directed directly to the organization without having that consent. It's just that no information would be documented within the system that could be shared with other providers. A few other key factors when we think about security and privacy: we're HIPAA compliant and HITRUST, SOC 2, and NIST certified. Those are, for those, I know there's a lot of experts on the call who know what those mean, but in short, we have industry-leading security certifications. Also, we've undergone, of course, with all of our dozens of government partners, hundreds of health system, health plan, and social care provider customers as well, have undergone extensive security assessments through basically every question that could come up. We do feature smart permission-based access to restrict access to information. So what that means is both at the user level and at the organization level, you can control who has access to what information. At the user level, what that means is, like, even within an organization, you can say, this user should not, we don't want them seeing referral information. We only want them sharing resources with individuals, and that can be controlled at the user level. In addition, I think this is really important given the conversations that have happened today in the post-Dobbs world, and with respect to some of the sensitive data that's been discussed, for example, domestic violence and IPV data or substance use data. We have heightened restrictions applied to that data so that no organization within the platform can see any indication that an individual is receiving those services or has worked with that organization. And so, very important, just an example, reproductive healthcare is one of our sensitive service types. So besides the organization that's providing reproductive health services, no organization on the platform can see any indication that that individual is receiving those services. And so very, very important that that sensitive data is subject to even heightened restrictions, so that even folks that are working on a care team together, that are coordinating care for a shared patient or shared client, still those sensitive service types are fully protected from view. And then, of course, all data is encrypted in transit and at rest with continuous vulnerability monitoring. I think an important part of what we do is, we talk a lot about privacy. I think the why behind this is also really important for folks to hear on the call. So What does it mean when you help facilitate more efficient workflows for community-based organizations? We've, individuals that have utilized Unite Us in a recent housing study reported a 63% reduction in physically unhealthy days and a 62% reduction in mentally unhealthy days. That's significantly associated with, these unhealthy days are a common measure used in healthcare that's associated with increased hospital admissions and medical costs. So really great impact there. We also had a recent pilot led by community health workers utilizing our technology that documented a 25% reduction in total cost of care. And that came from a pretty significant reduction in ED utilization and also a significant increase in behavioral health care utilization. So getting folks access to the care that they really need instead of just directing them to the emergency room, which we know is not a successful model. And then finally, I think in terms of hours saved, again, a huge focus of ours, we can't place the burden on the individual to retell their story every time. We can't place the burden on providers to have to manage data input and data intake at a way that's just not going to be sustainable for our providers. So with our system, we found that a health system that conducted its own study of their use of the system found that they saved almost 4 hours per week per case manager, which is a significant cost savings for them. So we've been working in Connecticut for a while. We're really proud of our work, again, with partners like the Connecticut Hospital Association and CT 211. We have almost 1,200 engaged and accountable programs. This means programs that are actively sending referrals and receiving referrals on the network in Connecticut. 75% of those referrals result in services. The average referral resolution time is around 2.8 days. And again, this is really pointing to some of the previous legislation that Connecticut has passed about how can a platform like this really help us understand health equity in the state. We've seen that the average referral resolution time for BIPOC individuals is 2.3 days. And we also see the types of services that BIPOC individuals are receiving. So at the state level, when you're trying to figure out how do we more equitably distribute resources to make sure that the needs of, for example, BIPOC residents are being met, we can actually identify what are the most common needs. And that changes over time. So month by month, quarter by quarter, year by year, we can see what are the needs, what are the capacity constraints, and then how do we equitably fund the system in a way to make sure that needs are met. The last thing I would add, I think it's important, I mentioned this at the top of the call, is just to understand what's happening at the federal level. So right now, because of course there's terrific work happening in Colorado, Virginia, Connecticut, Oregon, with respect to comprehensive privacy bills, we're also seeing efforts at the federal level to address this question of how to manage the interaction between the health and social care sector. So last year, the Office of Civil Rights from HHS put together a notice of proposed rulemaking, an NPRM, that is actually attempting to facilitate and make easier those connections between health and social care to reduce some of the restrictions that have been placed and made it more difficult, or frankly, that have left open questions for the health and social care sector, where folks are unsure exactly what it is that they should be doing. And so the Office of Civil Rights is really focused, at least this notice of proposed rulemaking was really focused on helping to clarify some of the obligations and make it easier for folks to coordinate care between sectors. So that's a really important item that we're tracking, and that I think that anything we do here should of course take into consideration some of the work that's been happening at the federal level based on some decades-long feedback from providers on some of the challenges coordinating care. And then I think what we also see from the Office of the National Coordinator for Health IT, the ONC, is an attempt to modernize information exchange to make it a little bit easier for data to be shared between health and social care sectors. Again, a lot of what we've seen is just these silos result in fragmented care records and result in fragmented care for individuals. If you don't know that someone, is regularly needing a food service and you're coordinating care for them as a care manager, it's often your mandate to have a better record of exactly, what their needs are across sectors. And so ONC has also been working to support that more seamless exchange between the health and social care sector. So I say that to say, I think I'm really, Unite Us strongly supported SB6. We think it strikes the right balance. I think that anything and we're also very happy to talk through additional supports that we can provide and how we can further protect individuals to connect them with care. And I would also look to what's happening at the federal level in addition to what's happening across other states. to make sure that we are supporting some of the work that's happening in tandem and not running into unnecessary conflicts. We know that care takes place across states. It's been mentioned on this call, especially with respect to reproductive care. And so making sure that we're tracking what's happening at the federal level as well. And with that, I'll hand it back to Senator Maroney.
Okay, thank you. Are there any questions? And I'll start. Okay, there is a hand raised. So let's see. Okay, Bob.
Thank you, Senator. Alex, I'm going to go ahead and ask what may be a stupid question, but and it may have been something you covered that I just flat missed. I think you mentioned that all of the providers or of either health or social care that are on your platform are restricted from further sharing information with other entities on the platform, or they are prevented, and I gather either structurally within your platform system or contractually or both. How are they prohibited from sharing that information outside other entities on the platform? What prevents that?
Yeah, yeah, I'm sorry, go ahead.
I just said, did I miss that? Did you cover that and I just missed it?
No. So yeah, they are technically prohibited. So again, consent must be documented. And if it's not documented, they cannot share referrals with additional providers on the platform. So just to be clear, that is a technical prohibition on our platform. There's also, of course, standard terms on our platform that prohibit sharing outside of the purposes that are permitted on the platform. Your question about what happens, let's say that someone wants to take information from the platform and then share it elsewhere, right? We like all platforms, we can't control what happens off of our platform, but we do have user level permissions to ensure that only org administrators, so only those who are in charge of the orgs, can actually access the sort of the full org's information and then export information for example, their own reporting purposes. So we do have user level permissions to protect against that. But of course, if someone says, as with Epic or with any of the other major systems, FindHelp, whatever it would be, someone wants to take a picture, for example, and share information, there's nothing we can control about that, but we have the strong protections on our platform to prohibit that type of sharing, both from a technical perspective and a user level permissions perspective.
That's very helpful. I'm coming from a HIPAA background and health plans, and although we welcome the interoperability rule that was recently pushed out, we're very concerned about what happens with the information once it gets in the hands of the consumer. She generally has no idea what they need to do to protect that information before they send it out further on the internet. But thanks you. That's been very helpful. Thank you, Alex.
Of course. I see Rep. Gilchrist's hand is up.
Okay.
Thank you. Maybe you did just. Oh, thank you, Senator. Maybe you did just address this, so I'm sorry if I might have gotten a little distracted. But the consent is required and documented for each referral. Does that go in the hands of the patient and the consumer, or does it stay on the platform itself?
It stays on the platform. So the consent is documented within the platform itself. Now, like I said, it could be the case that it's sent via text and then they respond via text, but then that's still documented and visible, and it's documented and visible it's way beyond a checkbox. You can actually see the format in which it was documented for the individual. So from an audit purpose, like a lot of our health plan and government customers really care to see that signed documented consent prior to each referral, and they can actually view that at any time. In addition, I'll add, I know we didn't talk about this in the earlier presentations, but there are actually additional consents that are required in some instances, and some of the folks on this call will know about this. For example, some organizations are Part 2 organizations that require a Part 2 specific consent. Our consent isn't meant to replace those more specific consents, but actually what organizations can do is they can upload their additional consents before sending a referral that's specific to that need. And that consent is treated with the same sensitive protections that we have. So for example, if you're a Part 2 organization, you obtain a Part 2 consent from someone, you can upload it to our platform so that you can see, the platform serves really as your client source of truth, as your patient source of truth for the folks you're serving. But that additional consent is still protected in the same way that all of the sensitive information is protected. So another organization that's serving that individual would never see that, the Part 2 consent or the any indication that they were receiving Part 2 services.
Fantastic. And I should have said thank you for this presentation. It's great to see you again and have you here. I have two more questions, if that's okay. One has to do with, could you just talk a little bit more about what those heightened restrictions look like, in particular for someone maybe with reproductive, with the reproductive rights and privacy protection?
Absolutely. Yeah, so we have two types of additional like heightened protections for sensitive services, what we call sensitive services and then sensitive organizations. So this is really important because there are two, the way we think about it is there are two levels of protection that's needed. So one is, let's say that an individual is sent to an abortion care provider, right? And they're sent for a reproductive health care referral, right? That reproductive health care referral, or actually, I'll use a different example. Let's say that they're sent a reproductive health care referral to a coordination center. So it's an organization that just manages, coordinates care and sends referrals to specific organizations, right? So that sensitive referral, even though the coordination center is not a reproductive care provider, that sensitive referral should still be protected. So no one else on the platform can see the existence of that sensitive referral. Now, in addition, let's say that now the coordination center documents that this referral has been received and wants to send it to the reproductive healthcare provider. They are able to do that, but again, that reproductive healthcare provider is actually a sensitive organization. So what does that mean? So let's say the coordination center wants to send not only the reproductive healthcare referral to the reproductive healthcare center, but also a food pantry referral. It wouldn't be enough protection if you protected the reproductive health referral, but not the food referral. Now, I'm using food just as an example. It could be transportation, for example. Let's say the reproductive health center has transportation advocates that help directly. It wouldn't be enough if you protected the reproductive healthcare referral, but not the transportation referral. Anything that's going to or from a sensitive organization is fully protected on our platform. So others can't see it unless they're directly engaged in that referral. And so you wouldn't see that individual received the the transportation or food referral to the sensitive organization. No other organization on the platform can see that. Again, because it's not enough if from our perspective, at least, and this isn't something that's really protected by law, but it's just how we've designed our system. From our perspective, if you know that someone is getting a referral sent to a reproductive health center, even if it's not for reproductive health care services, that could still, create issues. And so we protect those all referrals going in or out of sensitive organizations as well. We automatically configure Part 2 domestic violence and IPV providers, substance use providers who provide services for HIV and AIDS, and then a number of other legal providers, for example, a number of other providers as sensitive, and then organizations can elect to be can also elect to be configured as sensitive.
Great, thank you. That's really helpful to know. And then my final is for you and maybe John as well, if he's still on. You both mentioned permission-based access and then per referral consent. Hypothetically, if we were to move in the direction of requiring any non-HIPAA social organization, I'm still getting the terms, to enact, to have these pre-referral consent and permission-based access. Do you see barriers to that? Would that in any way impact the work you do?
Yeah, I mean, I think that what we often see is the nature of what is required by that consent is what can be complicated. So we've seen some states try to impose specific language or specific parameters around the consent. This is really just the way I think about this. This is PII. And so there are already statutes that protect PII under state and federal law, consumer protection statutes, for example. And so it's not that these CBOs are fully unregulated; they're not, and they also have their own standards. What we would find, I think, troubling is imposing new mandates on resource-constrained providers that require them to sort of redo their existing workflows. So that's really, I'd say, where the concern comes down. We want to make sure that anything that we discuss and introduce is keeping in mind that these are organizations that don't have large legal teams. They don't have, their focus. They at all times are thinking about compliance because they need to in order to receive the state and federal grants that they receive, but they don't have the firepower at all times to be able to manage complex mandates. And so thinking about what is it really in a targeted way that we think would protect consumers and those seeking care while not putting an undue burden on the organizations that really we haven't seen examples of concerning practices from, but that we still want to make sure are protecting privacy in the right way.
Great, thank you.
Great, thank you. So Alex, I do have a question. And actually, I see Antoinette has her hand raised. Oh no, that's the clapping. I'm sorry, I couldn't see the. Okay, so I do have a question. You've mentioned the study for health equity. One of the things we always want to be careful of when we pass legislation is the unintended consequences, right? And obviously, we can't think through all possible scenarios, but I've heard mentioned before that this may hamper ability for some research. When it was a few years ago when we were fighting the pandemic, we had used data to help the state fight the pandemic, and now we're mentioning the health equity. Given that there are exemptions in the bill for research for the public good, can you explain, just help me understand how what we do may have unintended consequences to prevent that research that you mentioned of how quickly certain sectors are getting services or whatever?
Yep. Yeah, I think that's an excellent question. I think that gets a little bit to this, like, what is it that we really want to mandate? So we know that state governments, not just state governments, but also those that are responsible for managing care of individuals, including health plans. We know, for example, like HIEs are also trying to figure out how do we help, exchange data securely using our systems to make sure that systems and, health systems, health plans, others are all using a single care record. We're not creating fragmented care records. That's going to make it impossible to do the types of analyses that you're describing. I think that there's always a concern that a more burdensome framework will make it more difficult for agencies to be able to access the health equity data that they need. We've seen that in other states. We've seen states impose more stringent protections in an attempt to protect individuals that resulted in, like less data being shared and then less actionable data for the state in the middle of the pandemic, and that was quite harmful to the state.
Okay, great, thank you. Antoinette?
Thank you. I did have a question. I put up the clap by accident, so I apologize. In terms of the specifics on the consent that you're speaking about within your system, is there a common practice for your company in keeping that consent alive? And what about the timeline for data storage and the process for removal of data at some point in a customer or a patient's lifeline within a care system?
Yeah, that's a great question. And it's interesting because there are sort of two different competing issues here. One is you want to have sort of currency with consent. And then the second issue is that these organizations that are, coordinating referrals on both in the health and social care sector have their own record retention requirements, either under HIPAA or other rules. And our system serves as their it is their system of record for these individuals. So it is how they are managing data for them and how they are retaining records for these individuals, for example. And so we, from our perspective, how we manage it, and we're still a young company, but there's a 10-year requirement under many states. And so we have data retention policies internally about when we destroy data in accordance, like when we begin to destroy data, but then separately, the individual themselves can at all times control when their data is removed from the system. So of course, individuals can revoke their consent at any time, and then also have their data removed from the system at any time. So we are at once managing the data retention and records keeping requirements of organizations, while also making sure that an individual, and this is true across vendors, an individual always has control over their data, so they always can revoke consent, remove their data from the system at any time.
Thank you.
Great, thank you. Are there any other questions? Okay, great. And Alex, please share the slides, and that way I can share them out with everyone.
Absolutely, will do. Thank you all for your time. We appreciate it.
Thank you. Okay, next Jordan Wrigley will present from the Future of Privacy Forum, and she's going to present on healthcare adjacent data.
Thank you so much, Senator, and thank you everyone for your time today. Just putting up my slides now. All right, so as I mentioned earlier, I am the health lead and researcher for FPF's health portfolio, which deals in anything from HIPAA covered data to non-HIPAA covered data to HIPAA adjacent data, as we're calling it here. A little bit more about the Future of Privacy Forum. We are a global nonprofit organization and think tank, and we seek to bring together folks from academics, civil society, government officials, et cetera, industry, to discuss and evaluate policy, legal implications of data use specifically around privacy and risks to it. Though we are based in DC, I'm coming to you from the Denver area, so let's hear it for the Rocky Mountains. Starting off, it's always great to set some boundaries around HIPAA. When we talk about HIPAA adjacent, we're often talking about data that is not covered by HIPAA, that falls outside of the realm of HIPAA. It's always worth keeping in mind that HIPAA was built in a very different time. The technological and data worlds look very different now. Wasn't really intended for healthcare providers and closely related entities. And those would include those under the business associate agreements or BAAs and entities with access to that personal health information, such as insurers or electronic health record systems providers. And it also facilitated the portability of health information as well as the privacy. So it became very important, as has been mentioned on this call, for various providers to understand the diagnostics and tests that other providers had run. For example, a general practitioner referring a patient to, let's say, an otolaryngologist or an ENT of some sort for a particular condition. HIPAA is really based, and I thought this was a really great illustration in John's earlier slide of all of the arrows kind of coming out from the health clinic that were covered by HIPAA. It's really based on that relationship and the status of patient, not consumer, but patient, and the relationship between patient and provider related entities. It's always worth noting historically that Congress rejected expanding HIPAA to cover health apps and similar data back in 2008 when they were considering and building HITECH, because it would be very onerous to try and figure out how do we define these new entities who are many and various and this whole new system of data flows. So that was rejected. However, new considerations always come up. Now let's talk about HIPAA adjacent health information or data. Fundamentally, in its makeup, it is not dissimilar from HIPAA data, HIPAA covered data. So things like vital signs, your trackers, your apps may ask for things like height and weight. Trackers may take things like temperature, blood pressure, heart rate, et cetera, and use those data points to infer things about health or suggest things about health based on previous health data and findings. Now, this shifts control of the information to the consumer, yes, as well as the companies that utilize that data to inform and bring better healthcare via those documented data and trackers. There is value in empowering the consumers who use these in health awareness and knowledge, and they're able to interact with providers in a more equitable way. So bringing in information saying my tracker shows that I'm having this heart condition puts a lot of power in the hands of especially folks who maybe have experienced marginalization or historically been marginalized in the medical complex. There's also value in the real world data collected here. So as many of you may know, not a great track record in the health research complex of including women in health research. So we exist at a constant dearth of understanding women's and menstrual needs, things like reproductive needs, PCOS, et cetera. We lack appropriate evidence base and database to make really good concerted healthcare decisions sometimes. There's also value in monitoring of chronic and disability conditions. In fact, tech has become so advanced in the healthcare space in many cases that the choice to step away and no longer use tech is not really a choice for many people. It would so significantly reduce the quality of life or even lead to a significant downturn in length of life that it's just really not a choice. Now, specifically, since we are now existing in a post-docs world, reproductive and sensitive data It's always worth noting that data collected has really not changed that much. The landscape has changed. There's an increased risk of data misuse that includes unfortunate enforcement of laws that may not be useful or valuable to particular people. Decreased ability to contribute data to that research. I mentioned closing those gaps in evidence base for women and folks who reproduce. Devaluation or inequities in consent. It's been brought up a couple times now that consent-based models are always challenging, and this is a historic phenomenon in the medical world, is we see in many cases people were consenting to procedures, medications without fully understanding what they were consenting to. There's also the issue of the social stigmatization of health as well as healthy versus unhealthy. There are recently some very interesting comments made between people about other people's body and their body types. And we really don't have a great inclusive definition for what is healthy versus unhealthy. So then how can we have a great inclusive definition for what is health data? Historically, we've used things like BMI, which is not inclusive, and there's extensive research showing that BMI is not always valuable. There's also increased importance on language alignment. A great example here is miscarriage. So miscarriage is not a medical term. The medical term for miscarriage is spontaneous abortion. So you can see where if the law prohibits collection of, say, data relating to miscarriage, that would be challenging for a company to figure out, what do we mean when we say miscarriage? Do we mean spontaneous abortion? What do we understand to be miscarriage versus an actual medical term? This also benefits in aligning companies and industry with providers and with consumers who are now kind of in this space of consumer/patient, with understanding what particular words mean in relevance to condition. Another example is the word diagnosis, which I've seen in several state laws and legislation now. A diagnosis, again, is a medical term that technically, depending on who you're talking to in the context, requires a provider to make based on tests, based on exams. Interestingly, there's also condition in many legislation, which again, what does this mean? Is that something that needs to be said by a provider and written down and documented by a provider or not? Is self-diagnosis acceptable? So considerations in HIPAA adjacent data. This is something coming from a background in technology and specifically medical research. Time and space is becoming very important in these conversations. Reproduction, menstrual cycles, those things are time bound, and we have pretty good ideas about how those timelines occur. So the important part may not be if a person visits a clinic, it's when they visit a clinic, especially as we keep having these conversations about where lines are being drawn in terms of gestational weeks. Metadata is also incredibly important to consider. Metadata is when the common way to discuss it is data about data. So if one has coordinates in a data set, but then maybe doesn't keep the when in the data set, they could still find that when of the reading in the metadata. So creating very complex data sets. To that point, complex data flows and systems, it only gets more complex as we go on. New services come into play, new ways of using data, new ways of processing data. There's a challenge to accountability here. Again, language. My background is in environmental health, and I do not love the term data ecosystem because you can't hold the clouds accountable for the rain, whether it kills people in a flood or saves people from drought. So there's a challenge to accountability in these complex systems. There's multi-party uses. We were just discussing that providers can go to other providers. There are other providers who provide different types of services in order to support healthcare. And it's always worth considering, again, leaving that room for research. Understanding women's health and uterine health, as well as ovarian health and other aspects of those reproductive needs. It's a whole body system. Everything can relate to that. So it's worth figuring out how to leave room for research and understand how to better understand those conditions. Just a few notes on Connecticut and health information, having looked at the a little bit closer at the Act, there is that carve out for HIPAA, exempts protected health information under HIPAA. The Act also creates an opt-out with respect to certain profiling. So profiling for the purposes of automated decisions. So that would probably be AI or algorithms to produce legally or similarly significant effects. Definitions also include decisions that result in the provision or denial of healthcare, which is an interesting one. And then sensitive data opt-in provides that the controller may not process sensitive data concerning a consumer without getting the consumer's consent. And then finally, a definition of sensitive data that includes revealing mental or physical health conditions or diagnoses. Now, again, just the simple inclusion of condition makes this a little bit more broader than, say, Virginia's. And with that, I will be happy to take any questions. This is our contact information. I can be contacted at jwrigley@fpf.org. If you're on the Twitterverse, you can also follow us at Future of Privacy.
Great. Thank you very much. Are there any questions for Jordan? So, okay, Melissa?
Thanks. Thank you, Senator. And good afternoon. It's now the afternoon, so good afternoon. I just want to circle back on consumer privacy for social care data as you were describing for us. I'm just wondering, is there an impact on a consumer's privacy or control of his or her data in several different consent models, two being whether an individual gives consent, which extends to all service referrals versus a kind of a per referral consent model?
Oh, this is a great question, and we are having many debates about this across the US as well as in Europe, and I think across the globe, is the idea of this universal opt-in versus universal opt-out versus individual choices. So there are various models and technical aspects here. And I do think there is a little bit of a difference as we look at scholarly studies about consumer understandings of opt-in versus opt-out. Generally, consumers are willing to give a full opt-in if what they see is an explanation that your data will only be used to your benefit or the benefit of the greater good. And that has to be defined. If we just say greater good, they're not sure, which is an interesting one that consumers now want specifics and plain language. And technologically, there are challenges to this in terms of doing a universal opt-out versus opt-in and versus individual. So having systems all aligned to the point where a consumer can say, no, thank you, I'm opting out, and have that signal go throughout all systems is very challenging if those systems don't all operate on the same basis of language. And I don't mean spoken language either.
Right, right. Good. Thank you very much for that.
Are there any other questions? So I guess, Jordan, I have a question related. I read an article back in June, I think it was, about a software that I believe doctors can get for free to check people in. So it's just for checking them in for their appointments. And I believe that their revenue model was they were selling prescription medications or something using the data when the people check in. How does that fit into what we're calling like this healthcare adjacent and regulating that type of data? Again, it seems to be that location data, right? Of knowing where people are if they're using it as the check-in.
That would be the primary use there, yes. If they weren't under a BAA, which would cover them under HIPAA, that means that they should not have access to any of the medical information that could possibly exist as part of that check-in. I would have to see the data set to be 100% sure, but my guess is that would be a location-based data set.
Okay, and so if they are under that BAA, then the data they're collecting is would be considered HIPAA protected?
That is my understanding, yes.
Okay. It seems like I guess the big issue, I guess, to me, is this location data, right? And how that can be used. And it's not just when people, have to opt in under our model, you have to opt in, but we do have a lot of exemptions for entities that may be collecting that location data that are not, for instance, a safe driver app, right? If it's for an insurance company, then that's exempt. So they're collecting that location data. So I don't know how. I guess my concern is are there certain locations that we need to protect, right? And so in Connecticut, for instance, it's a crime to reveal the location of a domestic abuse shelter or domestic violence shelter. So are there ways to protect that data? And obviously we probably can't answer that now, but these are things that I'm thinking about. How can we possibly address that with, when we update the bill?
These are excellent questions. And yes, it's really difficult to answer these because even without something like a appointment app, there are always Uber and other companies that need this data in order to pick a person up and drop them off, especially in the context where the person themselves might not be mobile. Precise location will be necessary. So there is no easy answer here, I would say at this point, but hopefully we can find a good one technologically and policy-wise in the future.
Thank you. Yeah, I need you to mention that the transportation. That was one thing I did notice in one of the earlier, I believe in John Grant's graph, right? So I guess if you requested transportation from a healthcare facility, is that become protected? But I don't, between other services, it seems like it wouldn't be protected, or as the HIPAA data. So definitely something we need to think about. It looks like we have two other questions now, Antoinette, followed by Dina.
Thank you, Jordan. I really enjoyed your presentation. Question, you were kind of hinting on this with your previous answer, but how do you feel about de-identified data and vendors' use of that and the processes by which they promise to de-identify and only use for their own internal program development?
How do I personally feel about it? Undecided. How does it look from a technical and policy perspective? Promising. De-identification and anonymizing things are interesting because people define them to mean different things. And it may be dependent on the data set and what is being collected for what intended use. And so I think it would be great to see clearer enforcement lines around this, because a company can say we've de-identified and we think we've de-identified this data, but it turns out perhaps they haven't because there were unclear guidelines around how, specifically technologically, how to de-identify or anonymize that data in that given context with that given data.
Thank you.
Mm-hmm.
Thank you, Antoinette. Dina?
Hi, Senator Maroney. Just wanted to clarify on the HIPAA covered entity data. One of the examples I think we were just talking about was a rideshare service. If someone got a ride to a healthcare provider, that's not protected under HIPAA. HIPAA data is protected only if it comes from the covered entity or the business associate. So, if you're using a rideshare service, they're not a covered entity and they wouldn't be a business associate unless they had a specific arrangement with like a healthcare provider to pick up patients. So just wanted to offer that.
Yes, that is my understanding as well. And thank you, Dina. It's a real challenge there because even if the rideshare didn't collect that app, I have in my car, maybe some of you have, there's little tiny trackers that can go in your car that can lower your overall car insurance costs if they see that you're a safe driver. Many industry vehicles now just include those. So this whole idea of location is trying to, keep water in a broken hose a little bit.
Great. Thank you. Are there any further questions? Okay, hearing none. Jordan, thank you very much for your taking the time to speak to us and for your presentation today. With that, I think that is it for our speakers today. I'll just go to my co-chair, Representative Gilchrist. Do you have any final remarks? So with that, I guess our next meeting is November 2nd. We're going to be speaking, again, that meeting is going to be focused on the AI and algorithmic decision-making, and it'll, again, be the same time, 11 a.m. Eastern, and with the goal of hopefully wrapping up by 1 o'clock. We actually did it today, so I have 10 extra minutes for a later meeting that we can run over on. So thank you, everyone. And also, actually, before I do, I forgot to thank, when I thanked everyone on this call, I guess he was implied as being part of the call, but thank Ken Sicenti from Bob Duff's office and Bob Duff for all of their work on the original, on SB 6, the privacy bill. So thank you, everyone, and we will see you on November 2nd. Again, if you would like to present or have that day, please reach out to me. Thank you.
Thank you, Senator.
Thank you all.
Senator.
Thank you.